Welcome, everybody, to another meeting of the Hemlock Society of San Diego, now in its 39th year of operation, trying to enlighten the public on options at the end of life. I'm Faye Gersh. I'm the president and the founder of this organization 39 years ago. I started this, was then a chapter of the National Hemlock Society, which is now out of business. Dementia affects 10% of those people 65 years or older, and 35% of those 90 years or more, often with profound cognitive, behavioral, and functional consequences. A person with dementia is likely to live with the disease for 4 to 10 years before death occurs. It is not curable. In the final stages, the person needs total care. The number of individuals in the United States with Alzheimer's disease, that's Alzheimer's, one part of dementia, is expected to double above the current estimate of 6.7 million people who now are diagnosed with Alzheimer's disease, just in the United States. Many people would not want to go through the final stages of dementia. They would prefer to choose a peaceful death before that end occurs. Current guidelines for medical aid in dying require mental capacity and a prediction by 2 doctors that death will occur within 6 months. This is not appropriate for a dementia patient who may have years to live without capacity. Today's lecture by law professor Thaddeus Mason Pope is for those who would choose to hasten their death before the last stages of dementia occur, or family members that they are responsible for or love. He is a foremost expert on medical law and clinical ethics, with a special focus on patients' rights, healthcare decision-making, and end-of-life options. Professor Pope is a professor of law at Mitchell Hamline School of Law in St. Paul, Minnesota. A lot of interesting things going on in Minnesota right now. And is ranked in the most cited 12th health law scholars in the United States. He has over 330 publications in medical, bioethics, and legal journals. He's spoken to the Hemlock Society of San Diego before. As always, a recording of this and his past talks will be on our website, hemlocksocietysandiego.org. It is my pleasure to welcome again Professor Thaddeus Pope on the topic, New and Emerging Right to Die Options, 12 Ways to Avoid Late-Stage Dementia. I'm sorry, but before he speaks, Pat Fisher will explain the new system for Zoom interface so that when he is finished speaking, the audience can ask questions and make comments. Pat?
Yes, there's a new button on your Zoom interface and it says more. If you look at your toolbar and you do not see Q and A, you should click the more button and choose Q and A. Because of the large number of participants for this meeting, we will not be generally monitoring the chat. So we're asking if you have any questions for the speaker, please enter them in the Q&A. And that's it.
Okay. Professor Pope, you're on.
All right. Thank you, Faye. So I'm gonna hold on, I'm just gonna share here. And then hold on, I'm just gonna move you guys over a little bit. Move you over a little bit more. Okay. All right, great. Thanks. Faye already read this title. Thanks. This is me, Thaddeus Pope. Thanks. Thanks again. Thanks for having me back. By my count, this is my 4th time speaking to the Hemlock Society of San Diego. I talked about dementia before. I talked about conservatorships. although talked about using MAID to avoid late stage dementia about 1 year ago. I'm really pleased that that video, which Hemlock does archive all their programs, now has over 2,000 views on YouTube, which by my count puts me in the top 10% of Hemlock programs.
Right.
Okay, and then just looking forward a little bit, I am hoping to see some of you at UC San Diego in May for the Fay Gersh Endowed Lecture, and then perhaps later in 2026 in Tokyo, where there's going to be the next World Federation Right to Die conference. Okay, so before the ICE agents,
Hang on a second.
I'm in Minnesota, so before the ICE agents show up, let's get going.
Searching. You're connected.
Okay, so we'll start here. This is Charlie. Charlie is told that he has Alzheimer's. Charlie's doctor sits down to discuss his healthcare options and what his future could look like. And Charlie learns that he's likely going to lose his ability to make decisions about his healthcare in the future. So Charlie thinks about this a little bit, and Charlie decides that he does not want to live into and with late stage dementia. So he asks about his options to hasten death. In other words, he wants an off-ramp, right? If he continues on the road that he's on, he's going to live into and with late-stage dementia. He wants to get off that road. He wants an off-ramp. And Charlie's not alone. This talk is for Charlie and many others like Charlie. So let's start with dementia. Faye gave us a little bit of background. More than 6 million Americans have Alzheimer's, and another million have another form of dementia, like Lewy body. 1 in 10 people over 65 has dementia. 1 in 5 between 85 and 89. 1 in 3 over age 90. Every 3 seconds, somewhere in the world, somebody in the world develops dementia. And there's a big fear of dementia, right? There's a lot of reports on this. More than 50% of respondents report more than just a little fear of dementia. This has been measured by AARP and their surveys. In this study, is different. They asked 4,000 people, what condition are you most afraid of getting? 18% of people said dementia. And other studies put this higher. This is a Harris poll done with this retirement program, and they found it was retirees' most feared condition of later life. You see Alzheimer's dementia at the top of the list, way above cancer, which is number 2. And other studies have dementia even more in the lead, right? So in this one, Alzheimer's at the top of the list, above cancer, above money problems, above everything else you might be afraid of. And this one puts it even way more in the lead, more than double of cancer. So dementia scares people the most. And those are just US studies. But it's the same thing. Just to give an example, this is a UK study. This came out just a few weeks ago, the Aging Index. And they found that now dementia has overtaken cancer as the greatest fear of the British. It is the most dreaded diagnosis, right? And that's why you have book titles like this. Oh, let me not get Alzheimer's, sweet heaven. Why many people prefer death or active deliverance to living with dementia. This is a JAMA study. 20% of people with a dementia diagnosis would want MAID. And what exactly, right? What exactly are all these people afraid of in all these surveys, right? Because dementia is, of course, a spectrum, a continuum, a long continuum. But what people are really afraid of is the right end of the continuum, stage 7 Alzheimer's, right? At that point, you can't interact with your environment. You need help with almost all of your activities of daily living. Your bowel and bladder incontinent, no intelligible vocabulary, you're non-ambulatory, you're unable to smile, unable to hold your head up. So, because of that, many people want to avoid living under those circumstances. They want to hasten their death to avoid living into and with late stage dementia. But how, right? How can you hasten your death? Well, some people do take a violent approach to this, right? So famously, Robin Williams. And many other people use jumping or hanging or guns or cutting. But those methods, right, aren't 100% effective. And there's a significant stigma attached to them. So we're not going to talk about those, at least in the prepared part of the presentation. But we are going to talk about 12 options. And we're going to put them into 3 categories: settled options, emerging options, and then future options. And this is obviously going to be a high-level overview of those options, right? If you just do the math, if I try to finish my part in under 60 minutes, to do 12 options in 60 minutes only leaves you 5 minutes per option. So it's going to be high-level overview of each option. Okay, so let's start with the settled options. So these ones have a solid legal foundation. But as we'll see, they do have some material limitations in their ability to achieve the goal of avoiding late-stage dementia. So option 1, the traditional advance directive, right? So this is a California advance directive. By the way, every single person on this call, whether or not you want to live with late-stage dementia or not, should have an advance directive. And then those of us who are seriously ill should also have a POLST. Now, with these documents, you can refuse life-sustaining treatment, whether that's dialysis, antibiotics, artificial nutrition hydration, mechanical ventilation, CPR, defibrillation, blood products, and so forth. But the problem is that a person with dementia may not be on any of that stuff. They may not need any of it. So some people say there's no plug to pull. They have the right to refuse it, but they're not on it in the first place. So even with an advance directive, declining all of that, a patient may still live into and with advanced dementia. Right? So it's like it's like an umbrella, right? An umbrella is designed to help keep you dry and not get wet, but you still might get wet, right? Even if you even with an umbrella, right? So a traditional advanced directive just might not be the right tool to get the job done of avoiding living into late stage dementia. So the key takeaways, and I'm going to recap each of the options. The pros: completely legal, completely available. The cons: it just might be irrelevant and unusable because you just aren't on any of those therapies. And so for more information, it's very easy to find information about advanced directives, but the UCLA Law Library does collect a lot of the really good links here. That's the first way to avoid late stage dementia, the traditional advance directive. Option 2, VSED. Voluntarily stopping eating and drinking, VSED. So this is done by a patient with capacity who is able to take food and fluid by mouth, but makes a voluntary decision to stop doing that, right? So they say no food, no fluids, no thank you. So this is different than refusing a feeding tube or artificial nutrition and hydration. It's different than the natural or organic loss of appetite at the very, very end of life. It's different than involuntary cachexia. This, VSED, is a deliberate choice to stop taking fluids by mouth. And the goal, the intent, the motive in doing that is to cause death from dehydration. And that will happen. We all need water. It's going to happen typically in 8 to 14 days. Now, the average is 10 days. And a lot of people say, 10 days? 10 days? Right? Because as we'll see, a lot of the other end of life options are measured in terms of minutes, right? And here we're talking about 10 days, right? And in fact, most people, if they had the choice, would prefer MAID over VSED, right? Like Wendy Mitchell, who used VSED famously, right, said, if assisted dying had been available, I would have chosen that in a heartbeat. So why on earth is VSED so popular? Well, two reasons. One is, to use the title of Peggy Baden's book, it's the least worth death, meaning it's the only option many people have. MAID's not available or they don't qualify for it. And then the second reason is some people, now this is the minority to be sure, prefer VSED over MAID, right? That's just the way they balance it, right? They say, hey, it allows more time to say goodbye. It is more natural than MAID, which involves lethal, medications. And it's more consistent with my morals and values. I don't believe we should have sort of an active intervention, some people might say. So we do have many, many VSED cases. They are collected by End of Life Washington, by VSED Resources Northwest. I collect a bunch of cases in this bioethics journal. We collect a bunch of cases in our book on VSED. But it's not just these first person narratives that we have about VSED. We have a lot of objective evidence about the patient experience, that it is peaceful and comfortable, right? This is a New England Journal of Medicine study. And in this study, they had 100 Oregon nurses caring for VSED patients. And those nurses reported that most of those deaths were, quote, peaceful with little suffering. And then late last year, me and a physician co-author published this article. This is a meta review, a systematic review in the Journal of Palliative Medicine. And what we did is we looked at 17 of the available empirical publications on VSED. And here's what we found. In terms of who, it's generally people 80 and older using VSED. It's people with dementia or another condition that makes them ineligible for MAID. And in terms of the VSED experience, the mean time to death is 10 days. And the caregivers, the family, found the preparation and the emotional toll of supporting VSED challenging, but reported that most of the experiences were satisfactory. We have professional society endorsements on VSED. So in the US, from the American Academy of Hospice and Palliative Medicine, the American Nurses Association, the American Medical Women's Association, the Society for Post-Acute and Long-Term Care Medicine. And same thing in Europe, a lot of professional society endorsements for VSED. We also have clinical practice guidelines telling clinicians how to do it. This is a really good book from the Dutch healthcare associations, but we also have US focused clinical guidelines as well. So just to recap, VSED, a validated and comfortable end-of-life option. And many have used VSED to avoid living into and with late-stage dementia. A lot of these cases collected at the End of Life Washington website. These two books, whole books, were published just last year in 2025, and a lot of other books were published in just the past few years about how a family member used VSED to avoid living into late-stage dementia. Two more books, And there's a film coming out this year about using VSED to avoid getting into late stage dementia. But that all said, there is a timing problem. And I'm going to come back to this timing problem with the other options, is that you have to VSED while you still have decision-making capacity, right? And a lot of people say, well, that's not so good, right? Because it means I have to VSED too soon at a time when my life is still worthwhile. So this is sometimes called an earliness problem, right? Now, some people think, oh, I can get around that. I can circumvent that. I'll VSED right before I lose capacity. Sometimes this is called the 10 minutes till midnight approach. So if you're going to lose capacity at midnight, you VSED it 10 minutes till midnight. But that is a risky approach because it is hard to prognosticate with dementia when you're going to lose capacity. And that window of opportunity could shut and you miss it. So people say, okay, I understand that. I understand what you're saying, Pope. I'll back it up a little bit. I'll build in myself a little bit of a buffer, VSED a little bit earlier. But now you're leaving even more good time, lifetime on the table. So, and people on this call might get this analogy. People, my law students would not. But back when radios, you had to tune them with a knob like this, right? It's like you don't want to do it too early, but you don't want to do it too late, or you can't do it too late, right? So this problem of premature dying, right? Your current situation today, right now, is still acceptable. So VSED's not a good option at this time because you're not ready to die right now. You're concerned about future circumstances where your dementia is going, where it's leading to. But you're going to lack capacity at that future time. So that's the dilemma. In the dilemma, it's now or never, right? You got to VSED now, or you're going to miss the chance to VSED. So that's the earliness problem. We're going to see this again, right? You have to VSED before you lose capacity in order to avoid something that's not going to happen for a long time. Some people put it this way. This is a very common phrase. You have to give up good days to avoid bad years. And sure, that's a trade-off many people are willing to make, but you do have to make the trade-off. So to wrap this one up, the pros, VSED, legal, and it's pretty available, right? There's a lot of death doulas that are offering this. But on the con side, it is very slow, 10 days, maybe 14 days. It's expensive, and it requires you to act prematurely. For more information on VSED, definitely check out these two books by Nancy Simmers and Kate Christie. Check out VSED Resources Northwest. And then almost every state has an end-of-life organization, and most of them now have a VSED section. Okay, and you're lucky, those of you in San Diego, because you have clinicians like Bob Uslander who have much experience with VSED, more than 100 cases of supporting patients with VSED. All right, that's the second way to avoid late-stage dementia, VSED. Option 3, made in Switzerland. So many Americans go to Switzerland for MAID, right? They go to Dignitas, they go to Pegasus, they go to Athanasios, they go to Phoenix, which is the successor to Life Circle, or they go to EX International. Some Americans go to Belgium, and the Belgian clinicians do help foreigners, but they're a lot more reticent and they want to have an established treatment relationship first. So let's just focus on Switzerland. Many Americans have gone to Swiss clinics, those 5 clinics, to avoid late-stage dementia. And some of the most popular webinars ever done by the Hemlock Society of San Diego are on this topic. And this got a high profile because the Nobel Prize winner in economics used this option. And there's a New York Times best-selling book describing this option. And that book is now being made into a film starring George Clooney and Annette Bening, right? So talk about getting a high profile. But you still have to do this before you lose capacity. So again, you have this timing problem. You got to act pretty early. So the key takeaways on this, the pros, it's legal in Switzerland. It's available, but it is expensive, and you do have to act prematurely. And for more information for Made for Switzerland, check out the switzerlandalternative.com, and then this book, Going to Switzerland, How to Plan Your Final Exit. And of course, the websites of the individual clinics. That's the third way to avoid late stage dementia, Swiss made. Option 4, inert gas asphyxiation. So I don't know where you're watching this Zoom call from, but wherever you are, you're breathing oxygen right now. If we were to replace that oxygen where you are with another gas like nitrogen, you would die. The good news is it would be rapid and painless. It would be quick and painless. And this is the option that's offered by Choice and Dignity, and perhaps more significantly, by the Final Exit Network. They will advise you on how you can safely and legally replace the oxygen that you're breathing with another inert gas. All they're going to do is provide you with information and advice. They're not going to get the equipment for you. They're not going to assemble the equipment for you. You got to do that all yourself for legal reasons. So in the context of dementia, Final Exit Network reported they looked at 500 cases that they were involved in between 2008 and 2024. During that time period, 14% of their clients sought their exit guide services because of dementia, and another 19% because of a constellation of issues, one of which often was also dementia. And they have a new book out called There at the End, and a lot of the cases in their book are dementia cases. So inert gas asphyxiation works fast, works painlessly, but again, you have to do it before you lose capacity. So you still have this timing problem. So the key takeaways on FEN or on inert gas asphyxiation, it's legal, it's available, but you do have to do it yourself. You're going to have to go buy the tank and the valves, and you have to put it all together, and you have to do it prematurely. So for more information on this, you can arrange a call with Final Exit Network about their exit guide services. And again, some of the most popular webinars ever done by the Hemlock Society of San Diego, these two describe the Final Exit Network and what they do. That's the fourth way to avoid late stage dementia, inert gas asphyxiation. Okay, so just to recap, we just talked about 4 settled options: traditional advanced directive, VSED, Swiss made, and inert gas. And they have some downsides, right? The traditional advanced directive might not work at all because you don't need antibiotics or feeding tube. Swiss made, VSED, and inert gas, they'll work. They will work to hasten your death. But you do have to use them perhaps earlier than you would like to. And Swiss made and VSED also pretty expensive, right? Talking $10,000, $15,000, $20,000. So let's turn now from the settled options that we just talked about to the emerging options. So these are already being used right now in the United States, but they're still maturing in terms of their support in the law and their support in guidelines. So option 5, VSED by advanced directive. So let's, just for a second, let's imagine it's 2032, right? 6 years in the future, it's 2032. You are in a bed in your house. You can't speak. You can't move purposefully. You can't recognize your caregivers. You can't recognize your family. and you're in diapers, and you're hand fed 3 times a day, very, very patiently, very slowly. It takes about an hour each time. This is your life. You never wanted to live like this, but you can't direct VSED now. You don't have capacity. You can't even speak. That's 2032, right? That's the situation you want to avoid. So one way to avoid it is today, January 17th, 2026, you complete an advance directive. And you direct in your advance directive, when I get, don't give me hand feeding. Don't give me spoon feeding by mouth. And when is that supposed to happen? When are we supposed to stop feeding you? Well, you can tell us what matters to you. You can put in clinical triggers. So you say, for example, when I get to advanced dementia, or when I get to stage 7 Alzheimer's, whatever matters to you. Or you could put a functional trigger instead of a clinical trigger. So you could say, when I don't recognize myself, when I don't recognize my family, when I can't go to the bathroom, or whatever else, whatever other condition you would find intolerable. And these My Way cards for natural dying, really good about helping you reflect on what those situations might be. VSED advanced directives are growingly popular. There was one printed in JAMA back in the 1990s, but now there's a whole bunch of them. There's the Dartmouth Dementia Directive. There's one from End of Life Choices New York, from End of Life Washington, from End of Life Options New Mexico, from Compassionate Choices, from Exit, from Life Circle, from the Final Exit Network, from Final Exodus, from the Lead Guide, Life Planning in Early Alzheimer's and Dementia. There are My Way cards for natural dying from Stan Terman. In Nevada, the official state advance directive form from the legislature has a dementia addendum that then has a VSED option. And then a lot of elder law, estate planning law firms offer their own dementia VSED directives. We offer one sample in the appendix to our book on VSED, and we have I think the best one of all. It's at the Northwest Justice Project. I noticed just in the past few weeks, Quicken Willmaker, which is at least they say they are America's #1 estate planning software. They now have a VSED option, right? So these big apps now include it. So a lot of VSED directives are out there. The value is that they avoid that earliness problem that we talked about, right? Because you're only going to get the VSED, the feeding is only going to stop when you reach the conditions that you specified were intolerable. But all advanced directives require some level of trust, right? That's the nature of them, right? And so there is this notion, I guess it's attributed to Napoleon, that if you want a thing done right, you got to do it yourself, right? So there's always a risk in delegating to others because they might not follow through. It's worth noting that even traditional advanced directives aren't always followed, right? Just to take some super recent high-profile examples from Southern California, right? The daughter of Elvis, right? There's ongoing litigation in LA that her advance directive was violated. And similarly, one of the richest women in the state of California, litigation that her advance directive wasn't followed. VSED directives, perhaps even less likely to be followed. In fact, some famous cases of people who had VSED directives, they weren't followed. So Margot Bentley and Nora Harris. 2 reasons for that. One is there is significant variability, right, in terms of the legal status of a VSED directive. So you can definitely do this in some states, but you definitely can't in others, right? So just an example, these are definitely legal in California and Vermont, and definitely not legal in Iowa and Ohio, just to give some examples. There's also a problem that we lack guidelines. So, in other words, you show up at Kaiser Permanente. They don't know what to do with the VSED directive because they don't have policies and procedures and training, right? And so there's a lot of professional societies say, hey, we need some more guidance documents on this. In fact, there's a lot of people calling for more guidance on this. Here in the BMJ, here. So the status of VSED advanced directives is still getting clarified. So key takeaways on this for VSED direct, it avoids that prematurity problem of regular VSED. But there is some clinician reticence, and it's not going to be legal in every state. Okay, for more information on this, check out, by the way, our VSED directive at washingtonlawhelp.org. That's the fifth way to avoid late stage dementia, VSED by advanced directive. Option 6, VSED by surrogate, right? So most patients lack advanced directives, including VSED advanced directives, right? So here, it's not the patient asking for VSED themselves, and it's not the patient asking for VSED with or through her advanced directive. So we don't have any first person authorization for VSED, right? It's a substitute decision maker, an agent or a surrogate asking. Again, this avoids the earliness problem because they're going to ask only at the time, but we do have that same two problems that we had with VSED advanced directives. Not legal in every state for a surrogate to ask for VSED for an incapacitated patient, and we also still lack guidelines. Plus, on top of that, this is always going to be a backup option. This is never a preferred option, right? Because you should really never just hope that your surrogate will direct VSED for you. Like, oh, I'm pretty sure mom would not have wanted to live in late stage dementia. I'm pretty sure that mom would have wanted VSED, right? Because one of your siblings is going to contest that, right? So give your agents, give your surrogates guidance and direction by completing an advanced directive, if that's what you want. So the key takeaways on this one, it avoids the prematurity problem, but again, there's some reticence in honoring these, especially in the long-term care setting, and again, variable legality from state to state. So that's the sixth way to avoid late-stage dementia, VSED by surrogate. Option 7, this one's pretty new, minimal comfort feeding by advanced directive or surrogate. So, as I said with the VSED advanced directives, clinicians are a little reluctant to follow VSED advanced directives, even if they are legally permitted, right? Because they say often, hey, if the patient's thirsty and the patient looks uncomfortable, we got to give them water. We gotta, notwithstanding what they wrote in their advanced directive 5 years ago, right? And in fact, the Long-Term Care Professional Society in the United States actually in 2019 put out a position statement saying, hey, long-term care doctors of the country, your duties to the current self, the patient in the bed right now, are primary, right? Despite what she wrote in her advanced directive. So if you got to choose between the two, you treat what the patient needs right now. In 2023, they retracted that, right? So they did retract it, and now they say follow the advanced directive despite what you deem to be the current best interest needs of the patient. But there's still a lot of reticence among long-term care clinicians. And you look at a lot of policies, it's a very large New York hospice. And even they say where the patient lacks decision-making capacity, VSED cannot be initiated, right? So they're not going to, they'll support you if you want a VSED and you still have capacity, but not if it's started by advanced directive or surrogate. And some other emerging evidence shows that the long-term care staff would experience significant moral distress having to watch a patient dehydrate to death in front of them. So we came up with an alternate route here to fix that, to address that problem. We call it minimal comfort feeding. So this addresses both the goals of the then patient, the one that wrote the advanced directive, that wanted to avoid living into late stage dementia, but it also addresses the needs of the now patient who's now in late stage dementia and might be thirsty. So what is minimal comfort feeding? Well, let me just contrast VSED. Remember now with VSED, you're getting zero nutrition and hydration. With minimal comfort feeding, you're getting some nutrition and hydration. So minimal comfort feeding, there's no scheduled meal times. We're not going to wake you up. We're only going to give you nutrition and hydration responsive to your discomfort. So if you appear to be uncomfortable, then we'll give you something. It's not going to be as much as you'll take, right? We're not going to keep doing it until you turn your head away. We're only going to give you enough to make you not uncomfortable. In terms of timing, remember, VSED takes about 10 days on average. Minimal comfort feeding is going to prolong your life. So somebody who's getting minimal comfort feeding, the evidence shows you're going to last for 2 to 3 weeks. So let me give you an example for this, right? Margot Bentley may be the most famous person with a VSED directive. So let's say that she completes an advanced directive. Let's say she even backs it up with a video, which is recommended, right? So it's not just the written document advanced directive, it's a video advanced directive. And basically she's saying, don't feed me by mouth when I reach advanced dementia. Now, let's say she does that today, January 17th, 2026. Now let's fast forward again. Again, it's 2032. 2032, she's in late stage dementia. Therefore, her advanced directive is triggered. Her caregivers honor, they follow the advanced directive, and they stop giving her nutrition and hydration. But then Margot says, hey, I'm thirsty. Now what are you going to do? Well, the idea of minimal comfort feeding is you're going to stop VSED and you're going to switch to minimal comfort feeding, right, to respond to her apparent discomfort. And you're going to give her just enough nutrition and hydration so she's not uncomfortable. And she'll die in 20 days rather than in 10 days, right? So we are still going to achieve Margot's, the patient's goal of avoiding living into late stage dementia. We're not going to achieve that goal as quickly as we would have with VSED, but we're still going to achieve it. And we're going to avoid staff moral distress from having to stand by and witness what they consider to be unmet suffering. So with minimal comfort feeding, you can basically have your cake and eat it too, right? The clinicians are not forced to choose between following the VSED advanced directive on the one hand and addressing the patient's present suffering on the other hand. They can do both. And some early evidence that's coming out right now shows that hospice and palliative clinicians strong level of support for minimal comfort feeding. So key takeaways here, it avoids the prematurity because it's happening at the time of the late stage dementia. It's more acceptable to clinicians than VSED advanced directives. The cons, it's super new and still probably variable legality from state to state. So for more information on this one, check out our open access article at the Journal of Pain and Symptom Management. That's the 7th way to avoid late stage dementia, minimal comfort feeding by advanced directive. Option 8, VSED bridge to MAID. So let's start. Let me just go grab a water here. We're getting to the end. Let's start with traditional MAID, right? Available now in these 14 red states. But they all have these 2 eligibility requirements. You have to have capacity and you have to be terminally ill, both at the same time. So you need to be in the final stage of an incurable and irreversible physical medical condition that will probably cause your death in the next 6 months. you need to be for MAID at the end of your illness trajectory. So can patients with dementia qualify for MAID? Well, asked like that, the answer is yes, they can. Patients with dementia can and already do qualify for MAID all the time, but it's a patient like this, a patient with stage 1 Alzheimer's and metastatic cancer, right? So she has dementia, but it's so early that she still has capacity, and she has a terminal illness, but it's not from the dementia, it's from the cancer. So technically somebody with dementia can qualify for MAID. But what people really want to know, or what they're really asking is, wait, what about somebody with dementia as their sole underlying medical condition? That's all they have. They only have dementia. No, they cannot get MAID in the US, right? They are definitely excluded, right? Because at the early stages of dementia, stage 1, stage 2, they have capacity, but they have no terminal illness. At the late stages of dementia, like stage 7 Alzheimer's, they might be terminally ill, but they definitely don't have capacity anymore. And also at that stage, they're not going to be able to self-ingest the medications, which is another requirement. So when we're talking about dementia as your sole underlying medical condition, you just cannot check off all of the requirements in the California End of Life Options Act or any other MAID law. So no MAID. If we assess traditional MAID using the little matrix I've been using, and I'm not even including it as one of the 12 options, right? The pros would be that it would be faster and easier than VSED, but the cons is that people with dementia as their sole underlying medical condition are just completely ineligible. Even if they were, it would still be premature. So VSED bridge to MAID, what's that? Well, the idea is the patient starts VSED on day 1. Let's just say, now, of course, you could just die from VSED, right? So you could just use that. But the idea is, so if you started VSED today, you probably would be dead by January 27th, 10 days from now. The idea of the bridge is that you start VSED today, but you switch tracks. You switch tracks, and you switch from VSED to MAID. So the patients start, and the reason is because when you start VSED, clinicians can certify you as terminally ill because VSED is going to make your death probable in the next 10 days, which is way less than 6 months. So the patient qualifies for MAID when they start VSED. So by day 3 of the VSED, the patient can get MAID. So instead of just continuing the VSED, right, starting today and continuing till January 27th, you start the VSED today, but then by Monday, today's Saturday, by Monday, you switch to MAID. And the value, of course, is that it's way faster than just continuing for 8 to 14 days with regular VSED. That helps the family, it helps the patient, and it's way less expensive. There are some limitations, right? You can only do this in MAID stage with short waiting periods, between the 2 requests that you have to make for MAID. And there are very few US MAID clinicians comfortable certifying terminal illness based on VSED. But it is possible for some. That was really the focus of the last webinar I did with the Hemlock Society. So check that one out. It expands it some more. But I gave this case of Cody Sontag. So the key takeaways here, the pros of VSED bridge to MAID, it shortens that long VSED time frame a lot. The cons, it's only available in some of the MAID states. Clinicians not so sure about this. And it, again, still requires you to act when you have capacity. So it still has the prematurity problem. For more information on this one, check out, I have these 3 articles on VSED bridge to MAID. And check out last year's webinar for the Hemlock Society. And if you're looking for a clinician, obviously go to aadm.org or your state end of life organization. That's the 8th way to avoid late stage dementia, VSED bridge to MAID. Option 9, do it yourself. Sometimes it's called self-deliverance. So we lost Derek Humphrey last year, right? Who real famous innovator of this. But perhaps the other famous innovator is Philip Nitschke, right? And so Nitschke, right, innovating a lot with the Sarco, and I think now the double Sarco, or and now the Kairos collar. There's test kits, so you could test Nembutal that perhaps you bought at a vet store in Mexico. There's the dementia switch, right? A lot of innovation coming out. So he's a really creative guy. But the key takeaways on this one, no rules, right? Because there's really no rules on the eligibility, but I think there's a lot of uncertainty about the legality of some of these, at least in the US. For more information, check out Exit International and the latest edition of Final Exit. So that's the 9th way to avoid late stage dementia, non-medical options. So to recap, those are the emerging options. VSED by advanced directive, VSED by substitute decision maker, minimal comfort feeding by advanced directive, VSED bridge to MAID, and non-medical options. And they have some downsides, right? A lot of uncertainty. Will my VSED directive be followed, right? Will my family follow it? Will my doctors follow it? And for VSED bridge to MAID, can I form a team? Can I find clinicians to support the VSED and to support the MAID, right? Can I put that team together? I don't know. So let's turn now, right, from the emerging options, which we just talked about, to the future options. This is the end. These ones are completely off the radar screen for Americans. So this is the future now. We're talking about the future, maybe 2030. Now, these options all exist, but they're not available in the United States. So option 10, US made. And what I mean is US made for dementia as a sole underlying medical condition, right? As we said a few minutes ago, they're excluded, right? But in California, as you guys know, in 2024, Senator Blakespear introduced a bill. This bill, SB 1196, which would have amended the End of Life Option Act to eliminate the terminal illness requirement, the 6-month prognosis requirement, and instead required that the patient have a grievous and irremediable medical condition, which would include a diagnosis of early to mid-stage dementia. So dementia would automatically qualify for MAID. Right, just as much. It would be in the category just as much as cancer and ALS, which are the top 2 reasons people get MAID. Now we don't know what's going to happen in 2028, but if we look at the trends, we get a little bit of an idea. Let me give you a sense of that. In Australia, 6 times in a row, 6 states in a row, all enacted MAID bills, made statutes, right? And every single time required terminal illness, just like all the US laws. Terminal illness, terminal illness, terminal illness, terminal illness, terminal illness. Then the ACT goes and enacts its MAID legislation, and it gets rid of the terminal illness requirement. And instead, you need to have only advanced and progressive medical condition. I think we're going to follow that trend. And that's good, right? I think that's good because MAID definitely preferred over VSED by most people. But you still have the timing problem, right? You still have the timing problem because you have to get the MAID while you still have capacity. So the key takeaways here, if we had MAID for dementia in the US, it would be faster than VSED. We wouldn't need to do this weird bridge thing in order to qualify for MAID, but it's not yet legal, and it would still require you to act prematurely. So for more information on this one, check out abetterexit.org, which pushed for the SB 1196. And there's a webinar on that at the Hemlock Society YouTube page. Option 11, made by advance directive. This might be the overall best option. This might be the best, right? So the idea here is you complete an advance directive like this one. This is a real advance directive for MAID, right? You complete this advance directive today, directing that you get MAID at some time in the future when your triggering conditions are met, whatever you decide those are. We talked earlier about the VSED advance directive. So this avoids premature dying, and it avoids the long duration of VSED because you're only going to get the MAID when the conditions that you found to be intolerable actually started to happen. This is only available in a few places. So the Netherlands, Spain, Colombia, and Quebec. Although there is a bill sponsored by this senator pending to make it legal in all of Canada. But in all of those places, it's only for residents of those places, right? So no Americans can access MAID advance directives, right? Again, we don't know what's going to happen in the future, but it is worth noting that we have looked at this before. We've tried this before. So in Oregon a few years ago, we did try SB 893, which would have allowed for MAID by advance directive. So the key direct takeaways on this one, the pros, it avoids the prematurity. The cons is it's right now completely inaccessible to US patients. And there is also, by the way, like any advance directive, we talked about this, it might not be followed. So even if it's legal, is a doctor going to be willing to show up and give you MAID years after you wrote your advance directive? So for more information on this one, I would follow what's happening in Canada. And then finally, MAID by surrogate. So let's say now you're in late stage dementia. You're there right now. You lack capacity to consent to MAID because you're in stage 7 Alzheimer's. You lack the capacity to do anything. And you forgot to fill out your MAID advance directive years in the past, assuming it was available. Right? So there's no first person authorization for MAID. You never asked for MAID. But your family, your daughter says, I think mom would have wanted MAID, right? We talked about this. She never filled out an advance directive, but we talked about it, right? So that your family, your surrogate, judges that MAID fits your goals and values. So this is now available in Colombia, right? Because there's a Supreme Court decision, this one, that authorized that. For years now in the Netherlands, we've allowed parents to choose MAID, especially for newborns with the Groningen protocol, but even for minors. And now in Australia, right, in the ACT, we're talking about the VAD attorney model. So what they mean by attorney model is durable power of attorney for healthcare, electing MAID for you. So in the US, it's worth noting, we already permit surrogates to withdraw life-sustaining treatment and in many states to direct VSED for an incapacitated patient. So I think it's logical to also at some point permit MAID by surrogate as well. So the key takeaways on this one, this would avoid the prematurity problem. The cons is this one is barely established anywhere in the world. So we have very limited track record to look to on this one. So for more information, I guess you have to follow what's happening in Colombia and the Netherlands. So to recap, those are the future options: US MAID, MAID by advance directive, and MAID by surrogate. They have some downsides. They're not available yet for Americans. And even if, for example, a person with dementia were eligible for US MAID, it would be faster than VSED, but you still got to act too early when you still have capacity. MAID advanced directives, we're still learning about those. And MAID by surrogate, we barely scratched the surface on those. So 12 options in 3 categories. settled options, emerging options, and future options. There's no right answer for everybody, right? This is a very preference sensitive decision, right? Each of us is going to balance things differently. And the things we're going to balance are probably things like certainty, prematurity, accessibility, and physical difficulty. So, with certainty, will I really avoid living with late stage dementia? Will it work? So, just to contrast, Swiss made and VSED definitely will work. Advanced directive for VSED or advanced directive for minimal comfort feeding might work if they're followed. Prematurity. Am I dying too soon when my life is still worthwhile? Am I giving up good days? Well, this is probably just the opposite. That problem is addressed by advanced directives, but for Swiss made and VSED, you're going to have to act too early. In terms of accessibility, can I actually arrange this? Can I put it together and make the plans to really get this end of life option for myself? Well, for this one, VSED, pretty accessible. Swiss made, a little bit more complicated. A lot of paperwork, a lot of screening. You got to do travel arrangements, a lot of stuff to go into that. And in terms of physical difficulty, can I actually do it physically, right? Can I do this end of life option, right? So here it's, again, just the opposite. Swiss made, pretty easy. All you got to do, depending on the clinic, is drink, 2 ounces of liquid or open a valve on an IV tube, pretty easy. VSED, really hard, right? 10 days of having all the willpower. So certainty, prematurity, accessibility, and physical difficulty. Each of us is going to balance differently, like what we're most concerned about, what matters most to us. Thank you. Thank you very much for having me back again.
So questions there. I think you addressed this, but multiple people are having difficulty understanding why VSED can be so expensive.
Yeah. So, and by the way, I'm supposed to remind you to use the Q&A function and not the chat function. Okay. The reason it's not necessarily that expensive, but it's often expensive. Okay, here's why. There's an 8 to 14 day duration, right? And at least after the first few days, the patient is going to need a lot of support. So even if you're on hospice, hospice only comes a few times a week, right? So there's 24 hours in a day. So you really, unless you have a big family and they're all willing to camp out, right, wherever this person is doing their VSED, and they're willing to do things like change diapers and clean the bottom line is it's often recommended that you get a death doula, you get some home nursing care, right? And so if you figure how many hours there are in a day over 8 to 14 days at $100 an hour, that adds up. So that's how you get to $10,000-$15,000 or more, is because of the home care, clinical support, home care, death doula support.
Thank you.
But it's variable. So if the more your family does, then you don't need to have paid caregivers to do those things. So the cost could be lower if you're doing it yourself.
When communicating with the public, does the economic argument work? Are people anxious about their taxes being used to keep the demented alive?
Well, so when you say the economic argument, so there's two. So some people are motivated, right? So even if for MAID, right, you look at the State Department of Health reports from Oregon, from California, and they ask people, why did you get MAID, right? So 3,000 people a year get MAID in the United States, more than 3,000. Many people list money, right? Because they would rather that go to their grandchildren, for example, than be spent, $10,000 a month for a memory care facility. So I think so money does motivate people. I think one is I don't want to live like that, but the other is I sure the heck don't want my money to be spent on that either, especially when I didn't even want it in the first place. On the tax question, I haven't thought about that. Um, it is worth saying, right? It's worth noting that people do spend down, and then they qualify for Medicaid. So a lot of long-term care is paid for by Medicaid, which is state and federal tax dollars. But I don't know of any studies that have assessed how people feel about public dollars being spent in that way.
Okay. What should a spouse do for their spouse who has mid or late stage dementia, who knows his or her spouse would not want to continue to live?
So, let me take some liberty with the question. Ideally, you would act before you get to mid to late stage dementia, right? Because the sorts of things that would give you the maximum amount of liberty, the maximum amount of power and control, would be for the person themselves, right, to complete an advance directive designating their healthcare agent, um, and if they wanted VSED, to put that into the advance directive. So, but the problem is once you lose capacity, um, then you can't do an advance directive. You can't do a durable power of attorney for healthcare. You can't do a VSED directive, right? So a lot of the power and control is would be maximized if you started planning before you lose capacity, which probably means before mid to late stage dementia. So once you get there, I think you do have a narrower range of options, right? So all the stuff I said, like the Swiss maid's off the table, right? Because if you don't have capacity, you can't go to Switzerland, right? You can't take another person to Switzerland and say give them maid, right? It always has to be first person. So I think that's that. I'll let you push back if you feel I haven't answered any of these. I'll pause and let you push back if you feel that's necessary.
Um, how do you know that severe dementia is the stage people fear most? Do studies show that?
Yeah, well, so that's a good question. I mean, I wanted to get to the 12 options, so I did present like 5 or 6 surveys. Some of those surveys didn't drill down in that narrow of a way, right? So they would just literally some of the surveys would just have cancer, money, stroke, dementia, right? And so it didn't break it down into any specific form of dementia. But other evidence, other studies do show that that's what people are afraid of, right? The most, right? So in other words, people are afraid of dementia the most. And then if you did a follow-up study and you say, okay, what about dementia? You said dementia scares you the most of all the things you might get. What is it about dementia that scares you the most? There are some other studies which do indicate that it is the later stages. I feel I went on long enough, so I didn't. But I'm happy. I'm easy to find, right? I'm easy to find. So if you're like, hey, where can you send me that study? Can you send me the citation? Just send me a message.
Please clarify the term lethal medications. Is it not lethal dosing of medications?
So when I said lethal medications, I was talking about MAID, the way MAID works in the 14 states. And so um, most clinicians use DDMA-PH, so digoxin, morphine, amitriptyline, phenobarbital, and so in the doses, right, that it's prescribed, it's lethal, right? So the medications, each of those medications by itself isn't intrinsically lethal. It's just that in the doses that they're prescribed for MAID and in combination with each other, they're definitely lethal. They're very lethal. because the doses are so high. They're way higher than they actually need to be to cause death, right? So there's a really good buffer built in. So that's what I mean. Is that I'm referencing the meds commonly prescribed for MAID in the U.S.
With VSED, what is the typical number of days when a person would lose consciousness? Do you think then the family is less or more hurting since the person is not now responsive?
So that's going to vary depending on your, what you would say is the baseline starting condition, right? So the whole period could vary from, some people die in 3 or 4 days, some people die in 15 days. So it varies, but generally it's the last third of the time, right? So if it's 9 days, it would be the last 3 days. If it's 10 days, so it's the last third of generally clinicians. So you could look at like Bob Uslander's website, Empowered Endings, or look at the books that I put on the slides. People generally break VSED into 3 groups: the early stage, the mid stage, and the late stage. So the late stage, they are very, very, very sleepy, sleeping all the time, or as you say, just completely comatose. Um, One thing that this raises, so yes, I think you're right. They're not uncomfortable, right? That's the hardest thing, is if the patient appears to be uncomfortable and in distress and suffering, then you're torn. Are we going to honor their VSED plan, or are we going to try to address that discomfort, which might mean giving them, 1, 2 ounces of water, which is going to subvert the VSED plan, right? So you're right. Once you're comatose, we're not torn in that way. One thing that is useful, I didn't mention this, is that it's helpful to have an advance directive, even if you start VSED with capacity, because that gives permission to your caregivers to continue your VSED plan, right? Because you're unconscious. It might look to outsiders, your neighbors, or adult protective services, that you are neglecting a vulnerable adult, right? So it'd be very helpful to have some documentation to say, no, 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 this is what she wanted, right? We're honoring her wishes, right? So for that last stage where the patient is no longer in control, she's given permission to others to not feed her.
Can an MD give comfort meds during VSED?
Yeah, that's a great question. This is why you really want to be on hospice when you are doing VSED, because that's a key value of hospice, right? Is you have a medical director, they're going to give you all, whether it's anti-anxiety meds, whether it's pain meds, whether it's morphine, whether it's whatever it is. Yes, so you do want to have somebody with prescribing authority on board with the VSED, right? So to do it, first of all, theoretically, you could do VSED just all by yourself, right? Just you and your mom, right? Bad idea, right? Bad idea. Theoretically, you could do it with just you, your mom, and a death doula. Probably also a bad idea, because to take your question is, you want somebody who can prescribe medications that the patient might need for comfort. And that's almost always going to be hospice. Theoretically, I guess you could get some kind of concierge home care doctor, but generally it's going to be hospice.
At which dementia stage is a patient typically considered to have lost capacity?
That's a good question. So capacity is a mushy topic in bioethics and in medicine, but probably 4 is going to be iffy, right? So I'd say generally it's going to depend on the person, right? Because they're going to make sure the question for capacity is, do you understand what we're talking about? Can you make a decision? Can you reason about a decision? And can you communicate that decision back to me, right? And so, Generally, people in 1, 2, and 3 probably can do that to the satisfaction of whoever is assessing them. Let's say it's made, right? So you're going to need to satisfy 2 doctors, right? The attending and the consulting doctor, that you still have capacity. And in Hawaii, it's going to be 3 doctors, right? You need to satisfy that you have capacity. But I think generally people in 1, 2, and 3 could probably do that. After 1, 2, and 3, I think it's iffy. And 4, I think, is in the middle. 5, 6, and 7, probably definitely no capacity.
Why would VSED not be legal in all states?
VSED is legal in every state. VSED is legal in every state. What's not legal in every state is VSED through an advanced directive. So VSED, the idea is it's your choice, right? And everybody would allow you, if you don't want something to go into your body, whether it's a spoon in your mouth or a needle in your arm, that's 100% your choice. And no state has taken that away from you. But when you want to do it through an advanced directive, now you are limited to what that state allows you to do with an advanced directive. So in Wisconsin, for example, they say Wisconsin says, hey, Wisconsin people, you can complete an advanced directive and you can decline medical interventions like mechanical ventilation and cardiopulmonary resuscitation, but you can't use your advanced directive to refuse oral nutrition and hydration by mouth. So that's literally what the statute says, right? So VSED legal everywhere. VSED by advanced directive depends on what that state's advanced directive permits you to do with an advanced directive.
Okay. And what was the name of the journal article you mentioned, Mr. Smith, that's the best on MCF?
Yeah, well, there isn't a lot on MCF. We sort of just invented it. It's Mr. Smith Has No Meal Times. It's at the JPSM, the Journal of Pain and Symptom Management, which is the flagship journal of the American Academy of Hospice and Palliative Medicine. And we paid the fee to make it open access. So even though normally it's a subscription, there's a $50 fee for each article, we paid so everybody can access it for free.
Excellent. In VSED Bridge to MAID, isn't the terminal illness supposed to be irreversible? And isn't VSED in fact reversible?
No, it's not. So yeah, this is a big source of confusion. When we use the word irreversible, there's 2 senses of that word. One is we couldn't reverse it. We just literally don't have the science, the technology, the medicine to reverse it. But there's another sense of irreversible, which is we can't do it because it's impermissible. Like we can't reverse it because the only way in which you could reverse it would be to restrain the patient and force feed her, right? If it's a capacitated patient who wants to VSED, we're going to say, no way, lady, you're eating, right? And we can't do that because it's illegal. It would be a battery, an assault and battery to do that. So it's irreversible because we can't reverse it. Not because we don't have the science to do it, but we can't do it. We're not allowed to do it. So that's what makes it irreversible.
Excellent. Isn't it true that most hospices aren't going to accept a patient with VSED at the beginning of the process because they don't want to help them to die, but to comfort them because they are dying?
So I don't know of a survey, but the evidence that I've seen shows that there's at least 4 categories for hospices. There's hospices that will support you right at the start, right? In other words, the VSED, they'll say, oh, you're starting VSED? That makes you terminally ill. You're eligible for hospice right now. That's the first category. Second category is the hospices will say, Well, we want you to be like a couple days in, maybe 2 days in, because we want to see that you're really doing it, right? Because we need to prognosticate to CMS, to Medicare, that you are probably going to be dead in 6 months. And once you're in it a few days, we have the right level of comfort or confidence that you're really going to do it. Some hospices want you to be in it even longer than that, and then some hospices are never going to qualify you for hospice based solely on the VSED. So I think those. So in other words, I think there's wide variability in how hospices approach VSED right now.
Okay. I have heard that there is a pill you can take, but you can only get it in Oregon. Is this correct?
I don't know anything about that. I think people reference a quote unquote a pill. That's not the way MAID works, right? It's a powder like the DDMA or the DDMA-PH. It's like I said, it's multiple different medications. They come in a powdered form. You mix them with 2 ounces of something, typically apple juice, and you drink it, right? So there's no pill, at least as far as U.S. end of life options.
Okay.
I'll say in the old days, this is more like 5, 10 years ago, we used to use Seconal, um, and you would get I think it's 9 grams. Uh, and so you would get 90 100 milligram tablets. Yeah, 90 times 100. Yeah. So that's 9 grams, 90 100 milligram tablets of Seconal. But it's those little oval shaped things. And you'd have to open it up and pour the powder out and then mix that up. So there used to be pills, but it was never one pill. It was 90 pills.
Okay. What is your response to the issue of a person with dementia being adamant that they wish to hasten their death at a certain stage of dementia with a dementia addendum, but then change their mind verbally after they lose capacity and become frightened of death?
So that's a super good question. So this idea of I call it, revoking your advance directive. So if you still have capacity, then definitely you can always, revoke your advance directive. So I don't want to do that anymore. But your situation is the patient does not have capacity, but it appears that um, they don't want their advance directive to be followed. Um, so let me give you the legal answer first. The legal answer is it varies from state to state. So in some states, you need to have capacity to revoke your advance directive. So whatever gestures or utterances you're making when you're incapacitated don't count. They don't count legally, right? So the advance directive would still be enforced and it still could
Good
and
girl. She's a very good girl.
should be
And
honored.
Pam is a
Um, but it's hard. Sorry. On the other, and then on some states, you don't need to have capacity to revoke your advance directive. So if you said something that suggested you didn't want what your advance directive called for, then even though you lack capacity, you can revoke it. So some states require you to have capacity for revocation, and some states don't require you to have capacity for revocation. Some states allow you to write, like your Vermont, allow you to write what's called a Ulysses clause. So the idea is you write down, you say, hey, my future self, in other words, the person anticipated what you just described, right? My future self might freak out and get worried about, being killed or, don't you listen to my future self. Listen to me. Listen to the now Thaddeus, not the future Thaddeus. Don't listen to future Thaddeus, right? So Vermont allows you to write a Ulysses clause like that, but most states do not. So it's a great question. It's really hard. And despite whatever the legalities are, it's going to be really difficult for the family and really difficult for the clinical staff wherever you are to figure out, do we honor the advance directive or do we listen to what the person appears to be saying right now? It's a hard question. I can't even give it I can't give justice in my answer to such a hard question right here.
Okay. There's a terminology question from Chris Palmer, asking it in the spirit of clarity rather than criticism. In your work, you use the phrases VSAID by advanced directive and VSAID by substitute decision maker. In both situations, as I understand them, the patient has already lost decisional capacity, and the decision to stop providing oral nutrition and hydration is implemented by others based on previously expressed wishes. Given that, I wonder whether retaining the word voluntary in those contexts risks some conceptual confusion. Would it be more precise, or at least less potentially misleading, to drop the V and refer to these practices as said by advanced directive and said by substitute decision maker, thereby reserving VSAID for cases in which a capacitated patient is actively choosing to stop eating and drinking? This question is especially sensitive when, as is often the case, the now patient with advanced dementia is begging for water. And then there's a related question. Maybe you want to tackle that one first.
Yeah, I mean, so that's a great question. By the way, Chris Palmer has a good book. Not drilling into the details on specific end of life options like this, but a good book on helping to think about end of life. Um, um, so I'll just tell you real quick. This is probably we could talk about this offline. Um, in our book, so I wrote, we did this with a palliative care clinician, Timothy Quill, and he pushed for that, and so that's the way the book comes out. Was we used SED by AD because that's what Tim really wanted. But then me and one of the other co-authors for the last couple years have thought, you know what, that was wrong. We shouldn't have caved into Tim, because it's the V applies because it's the patient's advanced directive. She thought about it. She reflected on it. She deliberated on it. It's her choice. She wrote it down. It's voluntary. So when it happens, it's pursuant to her permission, her direction. It's not contemporaneous permission, but the reason we're doing it is because of because the patient wanted us to do it. Yes, it was from a past decision, but it was voluntary. I get that I get the point, and I guess we decided to say, look, there's enough acronyms floating out there, right? Now we're using MCF. We thought for the sake of simplicity, we thought we should go with VSAID. But I understand the point. We probably should do some kind of Delphi poll where you go back, you get a big bunch of stakeholders and do successive rounds of voting to see what, a nice diverse group of clinicians and patient families think would be the right term. So I'll concede that it's not perfect.
Relatedly, could you say a bit about the legal and criminal law risk, if any, for clinicians or substitute decision makers involved in what you describe as VSAID by AD and VSAID by SDM? How should professionals think about that risk in practice?
Well, so the first thing is, like I said, VSAID by AD is just like in Wisconsin, Ohio, Iowa, right off the books, right? So those clinicians should not honor that directive. It would be like they wrote, I want euthanasia in their advanced directive. You can't honor that either, right? So in some states, it's easy. Definitely don't follow it because it's not a valid instruction. In California, in Vermont, here in Minnesota, it's a valid instruction. And generally, advanced directives should be followed. And so I actually think that you can get and should get disciplined or fined for not following a valid advanced directive. So it's not like, can I follow it? I think the question is, I think you must follow it if it's a valid instruction. Now, if you have a conscience-based objection, if you're a Catholic affiliated healthcare facility, then you can assert your conscience-based objection. But otherwise, you should follow valid advanced directives.
Okay. It is now 3 o'clock. We're officially over. There are still a few questions that haven't been answered. But I think maybe we should release Dr. Pope from his obligations at this point.
I'll answer them if you want.
Okay, cool.
You don't have to, you can cut this and post, the part that you want on in the
Right,
video.
right. Um, I'll stay and talk to you forever. Any printed education materials for long-term care staff regarding minimal comfort feeding? It seems each staff member may interpret comfort differently.
So super good question. So, no. So this article, this concept, you'll see that JPSM article that you asked about, it was only published last year, right? So it's not yet, there's no guidelines yet for how to do it. I mean, there are guidelines in the article, but not guidelines that have been adopted by professional societies or adopted by healthcare institutions or systems.
Okay.
So MCF really, really new, right? This is super. I guess I've given you stuff that's kind of, maybe I should have put that in the future options instead of the emerging options, but it is emerging. It's out there. It's floating. It's been presented at AHAPM, SWH, it's been presented at professional conferences. So I feel like it's off. It's in the, it's happening a little bit. And there are some studies underway. So there are patients right now who are on MCF plans, meaning they are incapacitated and they are only being given the absolute bare minimum amount of water that they need to not be uncomfortable. So they're not on a VSED plan, they're on a MCF plan. And they are part of a research, right? So that we're studying them to see how does that work? Are people comfortable with that? How long does it take? What's your path toward death? How long does that take? So it's happening, but it's still very new.
Okay. If I start VSED and then qualify for hospice, can I also have palliative sedation while continuing with VSED?
So yeah, so well, that's going to depend on your hospice. Palliative sedation, and I didn't even bring that up. You brought it up. That's its own complicated thing. And so generally, and the guidelines aren't consistent on it, but generally the idea is it's for intractable suffering, right? So nobody's going to give you palliative sedation or consciousness unless other things were tried and did not work, right? So your suffering needs to be intractable to other measures. And the other thing is they don't. So anyway, I guess the answer is I don't know. I think palliative sedation is also controversial, but maybe. I will note that in the Netherlands, where they study VSED, by the way, there's a lot of good research on VSED coming out of Switzerland, the Netherlands, and surprisingly, Japan. But the evidence shows that many of those VSED patients do get palliative sedation. So it is common. It is common to associate palliative sedation with VSED. But whether or not your clinicians would do that, I don't know.
Okay. There are a few questions here about inert gas, which isn't really the subject of this. Would you?
Well, I brought it up.
Okay. How available is inert gas? I have read that helium is harder to find.
Yeah, so I'm not going to claim to be an expert on this one, but I've had good discussions, with a lot of the key final exit people for years now, and yeah, they generally have switched to nitrogen. Nitrogen is pretty easy to get. There's, it's used a lot. I think I don't know what for welding or something, but it's around. So the gas itself, I think, or and the valves and so forth, it is reasonably accessible to get the stuff that you need. And that's the value of the final exit guides is they will tell you, they won't help you get it, but they'll tell you where where what you need to get and where you might get it.
With the inert gas option, should a family member be with you or should you do it on your own so they don't get charged with murder in California?
Yeah, so yeah, I might want to punt on this. So I guess it seems a little cruel, right, to say you have to do all by yourself. You know, we can't be here with you. But it does have the value. If you weren't even there, then you completely erase any possible allegation that you may have physically assisted the person, right? But to put the hood over their head, or that you may have held their hand, they may, or anything, right? That you participated in any way, because you can't participate in any way. The patient has to do it all herself. So if you're not even there, it makes it easier to prove that you had nothing to do with it. I will just note that just in the last 72 hours or so, right, there were murder. The grand jury did issue murder um, indictments in an inert gas asphyxiation case. So, but those people bought the equipment and help. So they did stuff that you are not supposed to do, right? The patient has to do everything herself, and they did some of the stuff. They bought the equipment, brought the equipment to her assisted living facility. So I guess yeah, I'll just stop there. It would be safer to not be there legally, but there's no automatic problem being present. But the key thing is that you don't touch anything.
Right. And if you do it with a final exit, they can be there with you.
Well, I don't know. So they may be evolving some of their plans based on this new case.
Oh,
So
really?
I'm not 100% sure on whether they'll stay or not. But yeah. But again, they'll check in with them.
Yeah. Okay. How do we deal with the mandatory feeding provisions in 25 states? They might override an advance directive for no hand feeding.
Well, right. I think that's what I was referencing when I said, when I gave the examples of Wisconsin, Iowa, and Ohio, is that I guess when somebody I don't use that phrase mandatory feeding provisions, but I suppose that's effectively what it is. So I would just say that you can't have a VSED directive in some states because. So I think we're talking about the same thing, right? So I'm very open about that. VSED by advance directive is available in a good number of U.S. states, but it's also not available in a good number of states because of, and it's fine, we could use that term, mandatory feeding provisions.
Okay. If a person has an advance directive indicating VSED desired if dementia, can the facility treat aggressively with morphine and potentially hasten death?
Well, you can not on purpose, right? You could, if the suffering, if they were suffering, physically suffering, yeah, you could give them morphine. And in fact, you could give them morphine that might hasten their death. But that cannot be the intent, right? You cannot give morphine with the goal of hastening their death, right? This is what we call the double effect doctrine, right? So if you give them a little bit of morphine and they still appear to be suffering, you can up it, give them a higher dose of morphine, give them a higher dose of morphine. So you titrate it, step, 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 stage, stage, stage. If it so happens that the morphine kills them, that's okay. But you're going to have to document very carefully that you were giving that morphine only to address suffering and not to hasten death. It's okay if it's a side effect, but it cannot have been the goal.
Okay. What is the status of SB 1196?
That's good. So that was in the 2024 legislature. So it never even got a hearing. It was scheduled for a hearing in Sacramento, and then it didn't even get that hearing that it was scheduled for. I don't know. Maybe I don't know if the people they're probably on, but they're affiliated with Hemlock, right? Whether or not Senator Blakespear or whether the guys who run a better exit are going to find a new Senate sponsor. So I don't know about the latest plans if there's going to be any plan for the 2026 session. But by the way, what happened in California, as you know, is Senator Blakespear pulled back. So SB 1196 died in 2024. Then last year, as you know, you did repeal the sunset, right? Because California's End of Life Option Act was always set to expire. We got rid of the sunset clause, so now it's a permanent law. So Senator Blakespear, I think, was going to do this in pieces. Let's at least do that. She accomplished that. That was signed by the governor. So maybe now that that's taken care of, we can go back and think about new things like dementia.
Okay. Uh, what are the two options that surrogates can currently do in the US? WLSD, and I'm not sure what WLSD means.
Withdraw life-sustaining treatment.
Ah, okay.
It's something that we use like in medical journals a lot because nobody wants to write withhold or withdraw life-sustaining treatment. So it's a real common acronym in the medical journal world. So it saves a lot of word count. Yeah. So your surrogate, and what I mean by surrogate is ideally everybody on this call would appoint an agent, right? So somebody who's appointed to speak on your behalf when you can't speak for yourself. So you use an advanced directive or durable power of attorney for healthcare. So everybody should do that, no matter what your wishes are. At least it's clear who it is that speaks for you. And if you haven't appointed an agent, then we're going to turn to what's called a surrogate, which is somebody who generally is just next of kin, right? So it's going to be your spouse, adult child, adult sibling, and so forth. Anyway, they do have the authority in every state to withdraw or withhold life-sustaining treatment from you, at least under some circumstances.
Okay, I think these questions are can you talk about terminal or palliative sedation?
So you asked about this, came up a few minutes ago. So I would say the reason I didn't include it as one of the options is because all the guidelines that there are. So the idea basically is that first I'll define it and then I'll give you the status. So the definition is we're basically going to sedate you so you're unconscious, right? And 99% of the time, well, the person also refuses artificial nutrition hydration, right? If you're completely unconscious, you can't eat, right? We can't even feed you by mouth because you're completely unconscious. You're going to be dependent upon a peg tube or some kind of feeding tube. So normally when people have palliative sedation or unconsciousness, they say, well, I'm going to be dependent upon feeding tube, but I don't want one, right? So they will die from dehydration. But the palliative sedation guidelines generally, not generally, almost always say that they don't want to hasten your death, right? So they only want to give palliative sedation to somebody who is already within like 72 hours of death, right? Because they don't want palliative sedation to be thought of as a means for hastening death, right? So they want to be confident that you were already going to be dead in the next 48 to 72 hours before they give you palliative sedation.
Okay. There's still quite a number of questions here and comments, but I think we should close it out. It's 3:15. A lot of people have dropped off by now.
Okay.
So thank you so much. It's a great presentation, Tad, and we really appreciate it.
Yeah, no, thanks for having me. It's always I love participating and I'm glad I get to come and do the UCSD thing in May. So, yeah, thanks again, everybody.
Thank you. Mm.